Prosecution answers Karen Reed motion. District Attorney Michael Morrissey filed a response to a defense motion in the Karen Reed murder case on Friday, urging the judge in the case to deny the motion that would see 2 of the 3 charges against Reed dismissed before the start of the retrial in the case. A mistrial was declared 2 weeks ago in the case, as the jury could not move forward on convicting Reed of any of the charges beyond reasonable doubt. After Reed's camp agreed to the mistrial, Alan Jackson, Reed's lead attorney and rumored romantic interest, filed a motion stating that they had heard from multiple members of the jury that the jury had voted to exonerate Reed of 2 of the charges. Jackson's campaign hit all the major pro-Reed outlets and TMZ and Fox News with the word that her defense believed that Reed could not be tried again on the 2 charges: second-degree murder and leaving the scene of a personal death/injury caused by the driver. The defense claimed that the mistrial was sudden, brief, and unexpected, even though there were 2 days of deliberations with notes from the jury that they were hopelessly deadlocked. Attorney David Giannetti argued both times for the defense in favor of the mistrial, claiming that the jury had enough time to deliberate to come to a conclusion that a mistrial was warranted. Morrissey argues that despite the defense claims of multiple jurors making unsolicited contact with them, the defense accepted the mistrial and no verdict was rendered by the jury. In fact, the jury being hung was the reason for the mistrial, and despite claims otherwise, the jury indicated that they could not complete their job and render a verdict. No affidavits or statements had been offered by the defense by members of the jury to back the defense's claims. The jurors' identities are also being kept from the public for another week due to safety concerns. Morrissey further pointed out that notes from the jury did not indicate agreements on the 2 charges that the defense is now claiming were unanimous decisions in favor of Reed. The notes indicated otherwise, that the jury was deeply divided and could not find a way to move forward in the case. The defense, when given a chance to inquire about the charges the jury was deadlocked on, declined to do so, according to Morrissey, and the defense pressed for a Tui Rodriguez instruction to force the jury into one more attempt to deliberate. After the mistrial was declared, the defense did not object to the hearings set to discuss the retrial, nor did it act to attempt to reopen the case until after the members of the jury supposedly came forward. Morrissey argued that the Commonwealth should be able to retry Reed on all of the charges, as a mistrial was declared and accepted by the defense. He also argued that the defense's claims of double jeopardy cannot come into play, as Reed's trial ended without a verdict. A hearing on the motion is set for July 22, 2024.